Okay, hello everyone. We're just going to give other people a moment or two to be able to join in, and then we should get started soon. So I'll just wait a few moments. Okay. Hello, everyone. Welcome to the North Hartford Promise Zone's Emergency Housing Resources virtual event. This event is going to be running from 6 to 7 p.m. today, February 25th, and is the third and final event of our winter virtual series. We are going to be having future virtual events, and we'll be sure to publicize those and give out more invitations for you to join us, and that information will be incoming. It's usually posted on our North Hartford Promise Zone's Facebook, Twitter, and Instagram. And we will be posting the links to that social media in the chat now. And we can post the social media links in the Facebook comments of our Facebook Live as well later on today. So our North Hartford Promise Zone Winter Virtual Events Series is a follow-up to our Fall Virtual Event Series. There were 3 events for each, and if you missed those, please do check out the NHPZ Facebook page for the recorded videos, and the link to those will be posted to the chat at the end of our event. So, in partnership with the Connecticut Fair Housing, we have staff attorney Melissa Marshall and community education specialist and tenant organizer Shazneen Hussein. So, if you have any questions for either of these speakers, please feel free to ask questions in the chat or in the Facebook comments at any time, and we'll be sure to address those during our Q&A session. So, speakers, whenever you're ready to begin, feel free to start.
Great, thank you, Anika. I hope you can all hear me okay. I am going to begin with a brief introduction. I'm Shazin Hussain, as Anika just mentioned. I'm going to begin with a brief introduction to the Connecticut Fair Housing Center and all of the different types of work that we do. But for today's session here, we will focus on pandemic-related resources that are available with regard to rental assistance and eviction prevention. So the center operates is a nonprofit, private nonprofit organization. It is also a civil rights organization, and we do a number of different kinds of work. Primarily, we offer legal services to address housing discrimination. And I just want to note that even during the pandemic, all federal and state fair housing laws continue to apply. So if you do feel that you have faced discrimination or you have questions about housing discrimination, please feel free to reach out to us. We also do fair housing education, testing, and investigation, along with foreclosure prevention, and as of today, eviction prevention work as well. So I think we will, and if you have any questions about any of the services and resources that we offer, please feel free to ask at during the question and answer session at the end of our presentation. So I think we will begin. I'm going to hand it over to staff and attorney Melissa Marichal to talk a little bit about the eviction process and the eviction moratoriums that are in place today or for a little while longer in Connecticut.
Good evening, everyone. As Shazneen was saying, I'm a staff attorney at the Fair Housing Center where I work on housing cases. So before we get into some of the newer specific COVID-related protections and related to eviction, we just wanted to start with some protections that always exist, no matter whether we're in a pandemic or in normal times. It's important to remember that that eviction is a legal process, and we often talk about, you know, in casual conversation, thinking about eviction as an event, but there are actually several steps that landlords must take to get court permission to evict a tenant. So the first step, formal step, is called a notice to quit, and that notice gives a date by which a tenant must leave, or if they stay past that date, that's when a landlord can go to court and start a court case that asks the court's permission to actually physically remove the tenant from their home. So it's important to always remember that in discussion about, whether someone is told to leave, that their landlord is going through the legal process, and that there's the opportunity to contest what a landlord is alleging in a case. And so the final step in the eviction process is when, if a court decides that the landlord does have permission to remove a tenant, then they sign a court order that's called an execution. And a landlord, if they get that signed by the court, they can then hire a state marshal who would then actually carry out the eviction. But before then, it's a court process, and tenants have the opportunity to appear in the case and defend themselves in that case. And before that execution order is signed, it's illegal for landlords to do anything that is impacting the tenant's ability to live peacefully and enjoy their home. So that includes cutting off the utilities, or actually, changing the locks on a tenant, or removing things from their home. All of those things are illegal until that end of the process, when they have that execution order and permission from the court. Do you want to go to the next slide, Jasmine? So then during the pandemic right now, there are 2 eviction moratoriums that are potentially applicable to different situations. And when we say moratorium, a simpler way of thinking about it is just an eviction ban. It's stopping or banning types of evictions or parts of the eviction process, depending on the situation. So that it limits the landlord's ability on what they can do right now. But there are exceptions. And so the courts right now, there was, at the beginning of the pandemic, there was a while where cases weren't moving much, and even the clerk's offices were limited access for only emergency cases. But starting on September 1st, all the clerk's offices opened up for all types of business. So the clerk's offices, where you would go to file papers in an eviction case, are open. And the way that the courts are holding court events like hearings is over the internet using Microsoft Teams, which is like Zoom. It's just a Microsoft application. And you can participate in the hearing by video, or if you don't have video, by audio on your phone or your computer. And that's how cases are proceeding right now. So there are exceptions to the eviction bans, and the cases that are exempt are moving. So it's important to know that tenants should not ignore any court papers they receive, even if they think that, that they should be protected by one of the eviction bans. You still should keep an eye out for any eviction papers and respond to them by the deadlines given on those papers. Next slide. Thanks. So the first eviction ban that we're going to talk about is the Connecticut eviction ban, which is a Governor Lamont executive order that's been extended a few times now. Right now, the executive order runs until April 20th of this year. So before April 20th, landlords can only file eviction cases for 4 reasons. Those reasons are if the tenant owes 6 or more months of rent that was due on or after March 1st. So on or after March 1st of the previous spring, if a tenant has since then accrued 6 or more months of rent, a landlord can file a non-payment case for that rent. If a tenant owes money rent that was due before March, so in February of 2020 or before, a landlord can also file a case for that non-payment. They can also start a case if they're alleging that the tenant committed a serious nuisance. And so those are like serious actions that pose like life, death risk to their neighbors or to landlords. And the fourth reason is if your lease is up and your landlord wants to move into the unit themselves. So those are the 4 types of cases that landlords can file right now and are filing. We are seeing landlords filing these cases. But if you owe less than 6 months of rent due on or after March 1st of 2020, your landlord can't start a case at least on that amount, at least until April 20th. Or if your lease is up and your landlord doesn't intend to move into the unit, then your landlord also can't start an eviction case for that right now, at least until April 20th. And then the major thing that the moratorium doesn't change is tenants' obligations to pay rent. So although it does prevent landlords from starting a number of types of cases, tenants are still obligated to make their rent payments. And after April 20th, unless this moratorium is extended, landlords can return to filing for any type of non-payment, even if it's less than 6 months. So I'm going to go to this next moratorium, but also just want to flag, I'm seeing some questions in the chat, and we'll definitely be able to review those once we just get through these slides. Happy to talk through those questions. So the second eviction ban is the federal CDC ban. You might have heard of this in the news about President Biden extending a federal eviction moratorium. So this moratorium runs through March 31st. It's different because it's not automatic, and it has a number of eligibility requirements. So we were just talking about the state moratorium where it's automatic and landlords can only file certain types of cases. But for the federal eviction ban, you have to affirmatively complete a declaration form and give it to your landlord. And only then do you get the protection of the federal moratorium. And right now, the way that the courts are considering the moratorium, it doesn't necessarily stop your landlord from filing a case, but if you've given your landlord a declaration and you qualify for the moratorium, it may be able to prevent the eviction from proceeding, from the marshal being able to remove you, at least through March 31st. So we recommend that people review the declaration, and we have links at the end of this presentation to more information about the declaration form and the eligibility requirements that we'll talk in the next slide a little bit more, and review them and make sure that they apply to you and apply to the other adults in your household. And then if they do, then every adult in the household should fill out a form and give it to the landlord. And if you're currently have an eviction case open, we also recommend giving a copy of your declaration to the court, so the court is also aware, because the court is trying to respect this moratorium, and so they're alerted to the fact that you have given this declaration to your landlord, then that can make a difference in how the case proceeds. And yeah, so again, that's through March 31st. The next slide. So like I was saying, there's a couple different requirements for the CDC federal moratorium. One of the biggest ones is that your household has to have lost income or have very expensive out-of-pocket medical bills. So if your income has remained stable, you know, for the past year, and there's no change there, you might not qualify for the moratorium. But if you have had income loss, or if you have very expensive out-of-pocket medical bills, and then you might be able to qualify. There's also an specific income requirement. If you qualified and received a stimulus check, that's sufficient. Or your total income is less than $99,000 a year, that's sufficient. Or if you didn't have to pay an income tax for last year, that's also sufficient. And then the three others are, if you have to be likely to be at risk of becoming homeless if you were evicted, or homeless, or have to double up in crowded conditions with friends or family. And the other interesting requirement is that you're supposed to be making your best efforts to pay rent. So if it does come up and the courts are reviewing declarations, and they could hold a hearing to question tenants about their eligibility, it's good to show that you're making your best efforts. If you have the ability to make a partial payment, that can be helpful. And the other thing is that you're making your best efforts to apply for any available government rental or housing assistance. And so we recommend in making sure that you can meet that requirement, it's good to call 211 to confirm what assistance might be available in your area, and if you can apply for that. So yeah, this is a lot of information, but we'll also share links with where you can review this on your own time at the end of the presentation. And now I'll hand it off to Shazeen to talk a little bit more about rent and rental assistance right now.
Thank you, Melissa. Yes, and I just want to note again that, as Melissa said, we're happy to take questions about any of this information in just a few minutes. I just want to cover a little bit of information about rental assistance that is available, and also that is some rental assistance that may be available relatively soon, I hope, as well as how to actually receive legal assistance or legal advice if you are facing an eviction case. So starting with paying rent, as Melissa mentioned, even though we do have these temporary eviction bans in place, tenants are still required to pay rent, and if they are not able to pay their full rent on time, still to try and make at least some partial payments as they're able to do so. So with that in mind, I just want to note that particularly with the state eviction moratorium, or the temporary ban that's in place via the governor's executive order, it states that, as Melissa said, landlords may start a new eviction case if a tenant is 6 or more months behind in rent, right? So in this case, if you are having trouble paying your full rent, if you can try to keep the total rent amount that you owe to your landlord under 6 months worth of rent, then this can give you a little bit more time and prevent an eviction case from being started against you, at least immediately. So even making smaller partial payments each month can help. And if you do make any partial payments to your landlord, or make any kind of agreement with your landlord that you will make fuller payments later, or that you'll make payments throughout the month, partial payments throughout the month, any payments you make to your landlord, any agreements that you might make with your landlord, we highly recommend that you keep a record of all of that, any communications and any payment records as well. Also, there is, before I just go to the next point about calling 211, I want to point out that there is also, it is still in the works and it is not open yet, but we are hoping that a statewide rental assistance program will be open soon. The federal government approved pandemic rental assistance, some money to go towards pandemic rental assistance. And so Connecticut has a share of that money that it is going to make available as rental and utility assistance to people who are in need. And as soon as that information is available, we will be happy to share that with everybody here, and also post that information on our website at the Connecticut Fair Housing Center. In the meantime, we recommend that if you do have trouble paying rent, that you call 211 to check and see if you qualify for any currently available rental assistance. For instance, I believe there is a smaller rental assistance program called the Homelessness Prevention Program. There are some eligibility requirements for this program that are listed here that I will go through. But if you are having this trouble, we do recommend that you call 211 and specifically inquire about rental assistance available in your area, and also particularly about the Homelessness Prevention Program. So in order to be eligible for the Homelessness Prevention Program, you should have received a notice to quit that Melissa mentioned earlier in the presentation. So if your landlord gives you a notice to quit, then at that time, you can call 211 and inquire about the Homelessness Prevention Program. You also have to be able to show that your overall, your gross annual income is less than 50% of the area median income. And if you're not sure if this is the case for you and your family, that you can look this up online, or you can call 211 and they will help you figure that out as well. You don't have, also if you don't have enough resources to avoid becoming homeless, in the sense that if you don't have any options and you think that you will likely become homeless if you are evicted, then you also qualify, or you are eligible for this program. And then lastly, the rent for your current unit, or if you plan, that is if you plan to stay, or if you're looking for a new place and find a new place, and if you plan to move, the rent for your new place or the current place has to be considered to be affordable. And again, this is something that you can verify when you call 211 and speak with someone about your eligibility for the Homeless Prevention Program. So we highly recommend that you check in case you are unsure as well. The governor's latest executive order also, or the latest executive order that spoke to pandemic housing assistance, also has a provision that says if you paid a security deposit amount of more than 1 month's rent when you moved into your current housing, that you may apply the portion that is more than 1 month's rent to any rent due, to any rent that was due or will be due between March 1st of last year through February 20th of this year. You have to make that request to your landlord in writing, so an email or a letter, and request this, and you should definitely keep a copy of that request. You may be asked to pay that security deposit amount back, but your landlord cannot require that you pay that back until the end of the pandemic, or until your lease ends and you're moving out. And then finally, just a note on how to receive legal advice or legal help if you are facing an eviction. So if you do get a notice to quit and you have questions, or you're not sure what to do, or you already have an eviction case that has been started against you, we highly recommend that if you want advice or assistance, that you call Statewide Legal Services. Their hotline is open Monday through Friday from 9 in the morning till 12 p.m. and then briefly in the afternoons from 1 to 2 p.m. And the number is 1-800-453-3320. And they will do a brief intake with you, ask you about exactly what type of situation you're facing, where you live, and then they might give you some advice on what to do with the eviction case, or rental, if you're wondering, exactly how to handle a notice to quit, or an eviction case. And also, if necessary, they will also refer you to a legal to a lawyer with one of the legal assistance organizations in Connecticut. For more legal information in English and Spanish, you can also go to the ctlawhelp.org website. They have legal information about a number of different issues, including different kinds of housing law. And then you can also visit the Connecticut Fair Housing website at ctfairhousing.org. And we have this information that we just presented to you on eviction bans. If you need to go back and check, or if there are any updates, we update that as well so that it's as up to date as possible. And then finally, before I end, just want to make sure that you have contact information for us if you do need to reach out to us or if you have questions. The Connecticut Fair Housing Center phone number is 860-247-4400. There is also a toll-free number, 888-247-4401. You can also contact us by email or just visit our website and contact us that way as well. And finally, right now, the Connecticut State Legislature is in session. And if you are facing eviction and you have had difficulty with housing due to the pandemic, we encourage you to reach out to legislators and to Governor Lamont and let them know your experience and let them know what kinds of services and resources you need at this time. And so just, I have posted the information to contact Governor Lamont and also how to look up your specific legislator at the Connecticut General Assembly website. And then that's finally, we'll take questions in a second, and that's Jenna's email as well at the North Hartford Promise Zone if you need to contact her as well. Okay, so I think I'm going to stop sharing the screen. I can always come back to this if anybody wants to see any of the information in the slides again, but we can take questions.
Yeah, maybe, I don't know if Jenna, if you want to coordinate this, but go ahead.
I can read off the questions just so that can hear them, and everyone who's watching it on Facebook and doesn't have access to the Zoom chat can see them, as well as I'm receiving a couple questions from Facebook. So I'll read them out, and we'll do our best to answer these as best as we can. So from the Zoom chat, we have a question. If you don't respond to an eviction notice before the deadline, will you still be evicted?
So this is a really good question. I think that there's sometimes, it's easy to think maybe it's better to not respond, and that might delay things. But in eviction cases, it actually just speeds up the process. So if you don't respond to an eviction notice by the deadline, and what we're talking about there, it's called a summons, a court summons, and a complaint. And so if you get a paper that has the word summons on it, I'll have some information about something called a return date, and that you have to file an appearance and an answer form within 2 days after this deadline that's called the return date. If you don't file by that deadline, what happens is that the landlord can file a request for the court to rule in the landlord's favor by what's called default. And so that just means that because the tenant didn't respond by the deadline, the other side, the landlord, automatically wins the case, and the court automatically rules in favor of the landlord. And then once that happens, the court can make that ruling, and then the landlord can go right ahead and request what we talked about at the beginning with the execution order, which allows a marshal to move out a tenant. So it's very, very important to respond by the deadline. And if you miss the deadline, there is, an opportunity to try to file what's called a motion to open, to basically open the case and explain why you missed the deadline and explain what defenses you think you have, and the court might allow that. But it's much, much easier if you just file by your deadline, and then they'll schedule a mediation where you have the opportunity to talk about trying to reach a settlement agreement with your landlord, and a hearing date where you can raise what you think are your defenses in the case. So yeah, definitely, if you don't respond, you could potentially just lose your case by default and be evicted very quickly. So we recommend responding by the deadline. Yeah, and then I think there's a second question from the same person, Hodan, which I can happy to go ahead and answer, Jenna. So the second question I can read out loud for everyone is, if a landlord wants to move into the place themselves, do you have any rights in order to stay? So I think what Hodan is referring to is how right now there's an exception to the state moratorium eviction ban protection that says that a landlord can file a case if the lease is up and your landlord wants to move into the unit. So in terms of rights in order to stay, you still have the right to, the landlord still has to go through the normal process of filing a court case and getting the court's permission. And you can still, present any defenses, and they have to prove their case. So if there's any question or doubt that you have about whether your landlord actually intends to move into the unit, you could raise that through the court process. And you could also, especially in cases where it's considered kind of like a no fault because you're paying your rent and you haven't violated your lease, your landlord just doesn't want to extend your lease and wants to move in, you can potentially request that the court give you more time to move out, to find a new place. The court is technically a court of equity, so they're supposed to consider, fairness in determining, making their judgments. So you can definitely still defend yourself and ask the court for more time. Also, if you think that you might qualify, if you might meet the requirements for the CDC moratorium, courts are ruling differently, but we generally think that it does apply in this type of case to cases where you are unable to move, even though your landlord wants you to move, because they want to move in. And so you could still consider reviewing the CDC declaration, seeing if you qualify, and filing that with the court as well. And that might potentially give you some additional time, at least right now through March 31st. So, and also if you have specific individual, you want individualized case advice, again, we recommend calling statewide legal services, and every, case is a little bit different, but that's some general ideas about your rights in that type of situation.
I see a couple more questions in the chat, and one is asking, Joshua is asking, what is forbearance, first of all, and I believe that's a question about mortgage forbearance. If I'm not right about that, you can let me know, Joshua. As far as, and Melissa, please, if you have any additional information, you can add to it. But I believe that for anyone with a mortgage right now, if they're having difficulty making their mortgage payments, they can apply for what is called forbearance. This is not exactly a payment forgiveness, but it is a temporary delay in making your full mortgage payment at this time if you're not able to. So there are some limited forbearance options for people who may have difficulty paying their mortgage right now. The best way to find out if you're eligible and if you can apply for a forbearance program is to contact your lender, your mortgage lender, and find out what programs they have in place. If your mortgage is a federally backed mortgage, then there are some federal regulations right now that outline some minimal forbearance requirements. And so you can check, there's a summary of the forbearance information on the Connecticut Fair Housing website under the foreclosure prevention section. But you can also call, thank you, Melissa. Melissa just included the frequently asked questions from the Fair Housing Center site in the chat if anybody would like to check that out. But yes, but again, you can call your mortgage lender and find out if you're not sure if your mortgage is a federally backed mortgage. The frequently asked questions there gives you some information on how you can verify, and also advises you to call your mortgage lender and find out if they have any forbearance programs that you may be eligible for. And then Joshua also has a question, is it possible for my landlord to evict me because I am elderly or have a disability that places me at increased risk of COVID-19? So I don't know, Melissa, if you want to take this. I don't believe there are specific eviction protections for people who are elderly or have a disability that places them at increased risk for COVID-19. But I'm not sure if that would be considered in any defenses in an eviction case.
So, so I'm not sure. I think, you know, again, every situation is a little bit different. And if you want individualized advice about that, your situation, again, we recommend calling the statewide legal services hotline. But generally, a disability or being elderly is not, doesn't provide a defense or protection to eviction for non-payment. So even during the pandemic, there's no special protection for those that are elderly or disabled and unable to pay the rent from eviction. So the normal protections would apply that right now a landlord can only file if the tenant is behind 6 or more months of rent that was due on or after March 1st of 2020. There's protections normally if you, for one type of eviction case, which is considered a no-fault eviction case where your lease is up and your landlord just does not want to renew the lease. In that case, depending on the size of your building, you might have more protections if you have a disability, but we would need more information to identify if that's potentially applicable in your case. But but I think generally, I guess a general message about that is if you're behind on rent, that status unfortunately doesn't there's no protection for it. But again, the CDC moratorium declaration might apply to your case, to any case where someone's not able to pay their rent and they're in an eviction case and they're facing imminent homelessness. And in any case, I think raising that you are at a heightened risk of contracting COVID-19 is always good to inform the court. And they might, again, they have some room to make kind of equitable fairness decisions. They'll consider what's fair to the landlord and to the tenant, and you might be able to request additional time, even if you end up losing your actual case. The court can decide when you actually have to move out by, and they have the power to postpone that to give you more time, and they might be more willing to do that if you are, especially vulnerable to contracting COVID-19.
That's super helpful. I have another question that came in. If I can't pay my rent, what is the next step? Do I try to negotiate? What do you recommend doing if you realize, the end of the month is coming, or your rent due date is coming up and you're not going to be able to make the payment? What should you do to protect yourself?
So I think one of the first steps that you can take is find out if there is any rental assistance available to help you make that payment. So, and certainly there are some other options that are maybe not directly housing related, such as applying for unemployment if you're eligible, that kind of thing as well. However, with rental assistance in particular, again, at this time, our recommendation would be calling 211 and specifically asking for rental assistance in your area, in your town or your city, and also particularly about the homeless prevention program to see if you are eligible for that. I'm hoping that in a couple of weeks at least, that we will have a somewhat different answer to that, because we are hoping that the statewide rental assistance program will be in place and that people can apply to that as soon as they know that they are not going to be able to pay their full rent in the upcoming month or something like that. So we'll keep you posted on that as well. Melissa, did you have anything to add to that?
Yeah, I think it's also good to stay in communication with your landlord. Sometimes landlords are willing to set up a payment plan or to accept partial payments or payments at different deadlines. So, I think keeping your landlord up to date and trying to work with them often goes actually a long way versus if your landlord doesn't hear from you, they might get more concerned and think more about taking legal action if it's available. But especially right now, where if you're only behind 1 month or anticipate being behind only 1 month of rent, your landlord can't start an eviction case right now for that. So they might be especially willing to make an agreement about how you're going to pay that in different installments. And if you do reach any type of agreement like that, our recommendation is to always get that agreement in writing. And in fact, in general, it's really helpful in terms of defending yourself, protecting yourself, taking positive affirmative actions, getting things in writing and having your communication with your landlord in writing can often, in the future be very helpful. So if you text message with your landlord or email with your landlord, having that proof that you made that agreement can sometimes make a difference if down the line there's any potential confusion or your landlord does file a case. There's sometimes crucial evidence about what happened when in text messages and email that's harder to prove when you just only spoke in person or only have phone conversations to rely on. So those two things. And again, if you also, another important thing is if you think that you might be vulnerable to an eviction filing, keeping an eye out for receipt of any papers is important too. The way that notices to quit and that first paper and the court papers, the summons and complaint work is that they are served and they're served at your home, at your apartment or your house, and they can be left slipped under your door, or they can be handed to you by a marshal or a third neutral party. But oftentimes we hear, the papers get lost, or you see them but don't really think about them. And so just being kind of on notice that, that you might get papers, and just to make sure that to watch out for them, because as I was saying before, being able to file things on time does help you defend yourself.
I would just like to add, for anybody who is currently living in public housing or has public assistance like a voucher to pay their rent, there is also an option of requesting a rent recalculation if your income has changed recently and you are no longer able to afford the portion of the rent that you're responsible for. So in that case, I can post a link in just a second, but there is on the Connecticut Fair Housing Center website a form that you can fill out in English or Spanish that will also allow you to request that rent recalculation from either your voucher administrator or your public housing administrators. So that's also an option if you live in public housing or you pay your rent with assistance such as a voucher.
I have one more question related to some of what you just talked about, and then we can get back to Joshua's question on the Zoom chat here. But what happens if a marshal approaches me? What are your rights in that scenario?
So I'm assuming you mean if a marshal is approaching you to hand off to serve some court papers. I think that, you know, you could technically refuse them, but a marshal doesn't have to be what's called personal service. They don't have to actually physically hand them to you in person. They can also serve them by what's called abode service, which just means they can serve it they can leave it at your home. So they can leave it at your door. The way that it's supposed to be is that they're allowed to kind of wedge it in your door frame. So anywhere where it's like wedged into the door, that's sufficient service. So in that hypothetical scenario, if you open the door and refuse to accept the papers and then close the door, a marshal could still just stick the papers underneath the door, and that's considered sufficient service. So it's kind of hard to avoid getting served, but once you do get the papers, definitely read them carefully, respond to any deadlines. And with that said, sometimes marshals do not serve properly. So if the marshal leaves the papers outside of if you live in an apartment building and the marshal leaves the papers in the lobby, in a common lobby or somewhere in the hallway, but not, like I was saying, wedged into the door that leads to your individual apartment, that can potentially be bad service, and that could potentially be a defense to your case. So remembering where you found the papers is helpful. And then if you call statewide legal services for advice about your case, they might ask you, where did you find the papers and how did you get these papers? Because potentially that's something you can include in your answer, and it might be something that means that the case can't proceed.
Thanks. And then the question from Joshua is, I am an off-campus college student, but I have moved home because my campus is closed. Is my lease binding? What can I do?
Yeah, so that's a contract, and nothing has changed contracts between landlords and tenants. So it's still binding. However, you're welcome to try to renegotiate with your landlord. I know that some landlords are willing, when you talk to them, to let them out of the lease. If you do end up moving out of the apartment, even if you're not able to be officially let out of your lease, the one protection is that if you move out before your lease is up, if your landlord doesn't let you out, you're technically liable for the rent due under that lease for the months that were left in your lease. However, the landlord has to what's called attempt to mitigate damages. That just means that your landlord has to make an effort to try to re-rent that apartment. So if they don't do that, that's potentially a defense to if they were to file a case against you in small claims court for the remaining rent, for example, and they hadn't actually tried to rent the apartment, made any effort, then that would potentially be a defense. So that's the protection there that does exist. But talking to your landlord and seeing if they might be able to negotiate a change in the lease terms is the best option. Are there any other Facebook questions, Jenna?
I see one that Josh posted. I can read it out. My kids are at home all day because of COVID-19. My neighbors have complained to the landlord that my kids are making too much noise. Can my landlord evict me because my neighbor complained? So currently, especially with the state moratorium against evictions, the temporary eviction ban that we mentioned earlier, I don't believe that simply a noise complaint can lead to an eviction case. Right now, the 4 reasons that Melissa outlined are the only exceptions to the eviction ban. So I believe that in a situation like this, a landlord could only start a new eviction case if one of the exceptions applied, and the landlord cannot simply evict someone or start an eviction case right now because of a noise complaint, unless the noise complaint is part of a serious nuisance. And I'm not sure, Melissa, if you want to add anything to that, but that is my understanding of how the exceptions work right now.
Yeah, exactly. And so just to give you an idea of like what serious nuisance consists of, a serious nuisance is one of a few different things. It could be inflicting bodily harm on another tenant or a landlord, destruction of the apartment or the building, anything that presents an immediate and serious danger to the safety of other tenants or landlords, or using the premises for prostitution or illegal sale of drugs. Those are the four grounds. So no, I don't think that a noise complaint would rise to that level. And it potentially wouldn't necessarily, different in normal times after the moratorium ends, not serious lease violations, nuisances could potentially be grounds for a landlord to start a case. However, this type of hypothetical where there's children involved and there's complaints about the noise is actually an interesting question of whether there potentially would be discrimination based on familial status. So if while extreme cases of noise could potentially be a nuisance or a violation of your lease terms, normal, living in your apartment as a family is not a violation of a lease, and there are protections, based on familial status. So we have received some complaints of landlords like serving complaint letters or notices to tenants complaining about noise of families. Everyone's home right now, and that means more time together. Kids aren't at school, but they potentially do have some protections too. So if you do think that you might be that your landlord or might be discriminating against you based on the fact that you have children living with you in your apartment, then I'd recommend giving a call to the Fair Housing Center, and we could assess, if that situation might be something that we can assist with.
And I think, again, as Melissa mentioned earlier too, I would just mention again here that if the landlord, sends a text or an email or a voice message or something like that, with the specifics of the complaint, that as a tenant that you save it and you keep a record of that, because that might be important in case it becomes an issue where the landlord tries to use that as a reason for an eviction at this time or anything like that. So in general, we recommend that if you do have any communications with your landlord, that you keep a record of those communications.
I don't see any more questions on the Facebook, and I think we have time to answer. Josh put another question in the chat, so we can answer that one and then wrap it up. So Josh says, I need my CPAP machine to sleep at night so I can breathe while I sleep. However, my power outlets aren't working, but my landlord said that does not count as an emergency repair and they will not fix the issue. Can they ignore my maintenance request?
So I think, yeah, do you want to start, Chesney?
No, I was only going to say that I believe there is a request that you can make based on the fact that this is related to a disability or a health issue that is addressed, that would constitute an emergency, especially if you cannot breathe without the CPAP machine.
Yeah, so I think emergency can mean, people have different definitions, but regardless, like Chesney was saying, if there's something that you want your landlord to do that that's necessary for you to live safely in your apartment, and due to a disability you need it, or a serious health issue, you can request a reasonable accommodation. And we actually on our website have a reasonable accommodation letter writing form that can help you fill it out and email it to your landlord. You're also welcome, to call the center and potentially a fair housing attorney or someone on our staff could talk a little bit more about the situation if you run into trouble with your landlord making this repair.
Yeah, I just posted the link to the disability or reasonable accommodation request letter generator that's on the Connecticut Fair Housing website. You do not necessarily have to use that in particular to make your request. You can make your request to the landlord through an email or a letter yourself, or even a text. Again, keep a record of those. And in this case, if the landlord has a policy that they do not necessarily immediately fix things like outlets, what you would essentially be doing, as Melissa said, is asking for an accommodation to that rule because of your disability and because of the need for you to have a functioning CPAP machine. So yeah, and again, these are, we don't know all of the details around these cases. So if you do have questions, or if you want to ask us about a specific situation, please do call us and let us know your questions and do an intake with us, and you can speak to someone who can advise you about the specific situation that you're facing.
Thank you all so much for a great Q&A. I'm going to hand it over to Anika real quick to wrap us up.
For sure. Thank you so much, Jenna. And that brings us to the end of our Q&A session. So this was our final virtual event for our winter series, Emergency Housing Resources. And were some really great questions. So a big thank you to both of our speakers, Shazneen and Melissa, for all of the helpful information today. Please look into CT Fair Housing to learn more about other programs and services they provide as well. And we'll be sure to make the links that are in the chat available to the rest of our viewers as well. We would really love to hear from you all, especially if you live in the North Hartford Promise Zone or are part of the Hartford community. So Jen is going to be posting a link to our event survey in the Zoom chat and in the Facebook comments as well. So we ask that everyone who has attended or watched, please fill out the survey so we can put out more helpful resources and events like this, and to learn more on how to serve the NHPZ better. So feel free to contact Jenna at jenna.vandoncelar@hartford.gov. There should be a slide if you want to rewind with her information, and we'll be sure to put out her email address as well so that we can learn more about the services that the city of Hartford and our Envision Center provide too. And we look forward to seeing you all at future events. Like I said, please feel free to follow all of our social media to keep up to date on what the NHPZ is going to be doing for our community. And thank you again, everyone. Have a great night.
Thank you.
All right.
Thank
Bye.
you. Good night.